Your kids will hate you. Folks, I got a question from one of our loyal YouTube subscribers. Hey Patrick, how can I leave something in my estate plan for my grandchildren without my children hating us? Folks, that's a valid question because I see that quite commonly. Bill and Mary, hey Patrick, we have 3 children that we love dearly, but their names are Mo, Larry, and Curly. And Mo has 2 children, and we would like to leave something to Mo's 2 children as well. What is the best, safest way to do that without hurting people's feelings and without disrupting the family harmony so we can keep the family on the front side of the cloud? Folks, I'm going to give the answer right now. Pull up your chair, get your pen out, get your notebook out, because you're about to learn here at elderlawcare.com. Folks, first and foremost, you want to put into your trust, if Mo, Larry, and Curly are your natural legal heirs at law, typically you're going to give them an equal share, a third, a third, and a third. But now you want to also include Mo's 2 children. Now you want to disperse it over 5 20% shares. If you just do that without the proper language in your trust, there could potentially be serious legal consequences and family turmoil. So therefore, this is what you must do. You must put proper language into your trust that Mo, Larry, and Curly, yes, they're getting 20% each. The remaining 40% is going to go to Mo's children. Also, folks, is a very important piece of the protection. My strong recommendation to you, if you were my client, I would advise you to have a family meeting with your family, with Mo, Larry, and Curly, maybe even the grandchildren, depending on their age, and let them know what your vision is and the reason why you're doing it, right? So it's best that they hear it from the horse's mouth, so to speak. Folks, if you have a family dynamic where you're not able to speak to maybe Larry and Curly, and you do not think that would be reasonable or come to the table and agree with your vision, then my recommendation also would be is to create special language in your trust called an interim clause or a no contest clause. That, in a sense, is a legal penalty clause. That way, if Larry or Curly were disputing their 20% inheritance, saying, hey, I'm a legal heir, I'm entitled to a third, and I didn't get my third, then that interim clause would protect your wishes significantly, because it's essentially a no contest clause. If they challenge your trust and the bequest in your trust, they could forfeit their entire share. So it's a strong penalty clause, but a very strong deterrent to prevent them from making drama when there should be no drama with your estate plan. So folks, hopefully you found this educational video helpful. If so, post a comment or a question and our member of our legal team will get back to you as soon as possible. Be sure to click the subscribe button and click that notification bell. And folks, if you'd like to learn more, pick up a copy of my books on Amazon. Patrick Kelleher, How to Slay the Four-Headed Beast. Folks, thanks for joining us here today at elderlawcare.com.